Good afternoon. This is Judge Alyssa Perez, resuming the criminal docket for the 210th District Court for November 1st, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
In cause number 2020-0D00795, State of Texas versus Ebony Rebecca Martinez. Announcement of counsel, please.
Samantha Rogg on behalf of the state. State's ready, Your Honor.
Miranda Pages from Ms. Ebony Martinez, ready as well, Judge.
Okay, and Ms. Martinez is appearing from the downtown jail. We are scheduled, let's see. We're scheduled today just for a status conference. It looks like, let me see what this bond order says on the 28th. Okay, so it looks like with her bond, they did a split bond for the DWI conditions. I don't have us down for anything else, Ms. Pages. How long has your client been in custody?
She was, I believe, picked up on, I want to say Friday or Saturday. Is that correct, Ms. Martinez? I think they're on mute. I can't hear them, Judge.
I think Friday. On Friday.
Okay. So, and that was on the outstanding capias, right, Ms. Pages?
Right, it was the outstanding capias, Judge. I did file a motion to recall warrant back in September, and I know that the court heard that.
Mm-hmm.
I could have sworn if, let me look really quick at my notes.
I see a few entries here and I'm trying to go through them because they just say other pleading and then it has like initials. So let me go through.
I thought I had submitted a motion to reduce bond, Judge, for her.
Does anyone see that, Ms. Nieto or Ms. Hernandez? Let me go back. I'm back on it for 4th.
When would it have been filed? Because I'm not showing it.
I don't see it either, Ms. Pages.
Okay, I'm only seeing the motion to recall warrant as well, Judge.
Okay, so we have, I guess, another window, at least one other window if you want to address the bond, but you need to file your motion. And if it's a matter of timing, in other words, not waiting until a jail docket, then please let us know that in your request for hearing if you waive your client's presence. But you need to get the motion filed and we'll schedule you. I know time is important, right? And so we'll schedule you as soon as I can, but I don't have a request. And I think that capias was outstanding for a while before we had Ms. Martinez turn herself in, or before she got picked up. Did she turn herself in or did she get picked up?
I believe she was picked up, Judge.
Okay.
And it is pending. I am showing that it is pending. I did submit it for it to be filed, but it's showing, the status is still showing as pending, unfortunately.
Okay.
I was hoping to hear that today just because she does have kids that are depending on her, Judge. I don't know if the court is able to hear the motion to reduce bond, or do you require the actual written motion?
So I would like to see the motion, but I think the state is entitled to notice, and I know they can waive that, but it's not scheduled today. What I will tell you, though, is once it has been officially accepted and part of the documents in Odyssey in the court's file, that I don't have a problem going outside our 3 p.m. Tuesday date if she's still in custody to address the bond, as long as the state is in agreement and you're in agreement.
Okay, sounds good. Thank you so much, Judge.
Okay,
Yeah,
thank you. Monday.
Sorry, just to let the court know, she was also booked on the bench warrant for violation of probation.
I forget that part. That's right. She's got I'm just thinking now in terms of the DWI, but the thing is that she was on probation on another case. Yeah, so that's part of the issue too. Was she on deferred, Ms. Ortiz?
Yes, Your Honor.
Yeah.
So let's make sure, maybe was it filed in the probation case, Ms. Pages?
No, I just checked it right now and it's not in there. And I know I had requested it on the new case. But I'm not seeing it filed anywhere, so.
Okay, and so for purposes of today, this was actually also set for a probation status hearing today. So I don't recall if we called both cause numbers. But in any event, I know we're looking at the bond. I know that, Ms. Pages. So just get your motions filed, and again, we'll readdress. If you get it, bring it to our attention. We could probably have it as soon as next week. Okay,
Okay.
like next Tuesday if we don't get it sooner. Okay.
Okay, thank you so much, Judge.
Thank you. Okay, is that all we have at downtown?
Yes, Judge, that's the only person we had downtown.
Downtown, thank you very much.
You.
Who's next?
Annex, page 6, Judge, top of page 6. Annex, may we have a Carrillo, Cristobal Carrillo?
And we do have the request in for transport, correct, on Mr. Carrillo?
Yes, Judge.
Your Honor, Mr. Carrillo is on his way. He was the last one that we were missing, but we got everybody else.
Okay, we'll come back to Carrillo. He'll be next up as soon as we get him.
Yes,
Who's
sir.
next?
Annex, may we have Alvarez Joseph?
Yes. Yes,
Bottom
sir.
of page 5, Judge.
All right, go ahead.
In cause number 2021-0D02640, State of Texas versus Joseph Angel Alvarez. Announcement of council, please.
Wawa King for the state of Texas. State is ready. Good afternoon, Your Honor.
Good afternoon.
Greg Anderson for Mr. Alvarez, ready to proceed, Your Honor.
And Mr. Alvarez is appearing remotely from the jail annex. We were scheduled today for final hearing plea deadline and our backup trial being this Friday. We had a previous setting and we had so many technical issues. It was a setting for the motion for continuance, I believe back in the beginning of October. We weren't able to accomplish that. And I think there were some other complications, but it was reset for today as well. Now, I can tell you, just looking over the trial docket for this week, I had noticed that we had 2 outstanding motions to suppress filed by Mr. Anderson. One, I believe, I want to say it was filed back in August, and I had seen that one, although I don't have requests for hearing on either of these. And the second motion to suppress, of course, was a supplemental motion filed on the 24th. None of those, Mr. Anderson, I verified with my staff and checked my own emails. Had I received any requests for hearing? Am I correct on that?
That's correct, Your Honor.
Okay, and so we're really pushing up in terms of the motions to suppress. Just reviewing the case, there isn't a lot of movement beyond that. And so I really need to hear an update before I will consider the motion for continuance. Ms. King, you want to start?
Yes, Your Honor. So I actually met with Mr. Anderson yesterday, and there is just the case itself. There is a lot of discovery specifically in this case. Mr. Anderson did request for certain discovery items. I have worked diligently and sent it to him. I believe that would be some of the basis in his supplemental motion to suppress. Also, he did request for an evidence review on this case. We do have one scheduled 9 a.m. this Friday. There is a lot of physical evidence, so I do foresee that evidence review taking at least half a day.
I guess a little bit of my question here is, we had a previous trial date for which you all, let me see. I'll say you all, but really, I think from the time when this was indicted, and let me go back and look at the hearing dates. Looks like our first jury trial setting was less than a year. It was in May of this year. And without verifying if there had been a motion for continuance filed by either side, I feel confident in that we would have had a discussion how overall that trial setting was not very realistic, which is why we had the backup setting here. Now, with that said, I'm still kind of wondering why we're at initial stages. of reviewing evidence and other things when we're already at our backup trial, because clearly we're about a year and a half then away from indictment. So why hasn't anything moved in this case?
Judge, I had an appointment with Mr. Briggs in the case. It's probably been 45 days. I'm not sure exactly how long ago it was, maybe before he left the DA's office. The purpose behind it was to look at both the physical evidence as well as there was missing, I guess I'll just call it discovery in the portal. And so we were going to sit down and look at that and discuss why I didn't have access to various pieces of documentary evidence, in fact, but also to look at the physical evidence. I think, well, I mean, maybe 2 weeks, maybe 3 weeks before, well, actually, I think it was maybe the week before he left the DA's office, we had an appointment to look at that information the following week. The physical evidence obviously is primarily the stuff which was found at the crime scene, but there was also significant material which was found at in a search of my client's house. Much of that was not uploaded on the portal as best I could tell, and that's why I felt as though I needed to look at the individual pieces of evidence to see what had been produced. It was described in some fashions, but in many cases, what was seized apparently at the house of my client either was not photographed or did not appear on the portal. So, secondly, Your Honor, there's a lot of the part of my delay in pursuing the various motions is that a lot of the documentary evidence was not produced. And by that, what I mean is the several search warrants were not on portal, nor were they included in any discovery which was provided to me. So for instance, you saw in my supplemental motion, primary reason for that was to kind of shake the cages and see if I could determine if those things, search warrants, were actually appropriately pursued by the police department, or whether they had seized, for instance, my client's Gmail account inappropriately. All the stuff on the portal didn't support the data which they actually claimed to have, and which they actually did provide to me. I just had no clear way of knowing how they had obtained, particularly the social media information they were going to use against my client. Ms. King and I did meet yesterday, and she has assured me that material will be provided to me. I did receive, I think, just today, a copy of the search warrant which authorized seizing my client's Google account, Gmail account, or at least arguably it does. Now that I can look at it, I will know, exactly how I would proceed with the motion to suppress, because it will address that particular search warrant. I'm thinking that there's probably many others out there which were never, like the Facebook account, for instance, Ms. King. She has told me that the detective is attempting or has downloaded those on the portal, although there's so much material, I did not see them as I looked for them prior to the hearing. So, Judge, again, part of the problem I had in pursuing the motion was I don't want to waste your time by, for instance, having a hearing where there actually was a valid search warrant, seizing evidence. But until I actually saw them, I didn't feel like I'd be prepared to have a hearing where they would then produce the warrants actually in the hearing. And I had not had an opportunity to look at them and be able to assess whether it's a valid warrant or not. So they are dribbling in. And I do think that assuming I get all those in the very near future, I should be able to identify which motions I will legitimately pursue. Because once again, I think I can evaluate which ones are valid and which ones are not, or at least close to it, and make a decision whether I need to waste your time on it. So
In your
guess
honor,
that's my excuse on it, Judge.
in your honor, if I may, so the system that the police department is using with CAP, it's WebRMS, which is what Portal pulls out from. In this particular case, there was a lot of documents and supplements that were titled as locked. So I addressed that with crime against persons. And so they have now unlocked, I guess, because of who was involved in this case and the sensitivity of the information in this case. So that was a lot of, because I was not even able to see any of that information. So, but I have addressed that with the police department.
Okay, so I need to know a couple of things. Still, that doesn't, I appreciate, Mr. Anderson, your attempt to kind of rattle the cages, so to speak, but it doesn't ever sit well with the court when we have a case as serious as this one, kind of just sitting around with, you know, no review as to what available evidence there was or not. I understand that Mr. Briggs may have been the point of contact up to a certain point, but, you know, it still leaves a good portion. I actually can't even think of what the timetable is there with Mr. Briggs no longer being with the office, where we were not moving on some of these things, especially if it was something as simple as unlocking documents or access by defense counsel, because however long it is, it's a delay and is certainly not being diligent in terms of our current trial setting. With that said, let me ask you, Mr. Anderson, as you have now kind of had some further discussions with Ms. King, do you feel, unless obviously something were to come out of this newly unlocked after your evidence review that may be somewhat of an ongoing thing, have you communicated to the state what you have identified thus far as being, say, missing or not turned over? In other words, is the state on notice of everything that you have concerns about up until this point so that they can either already have addressed it or be able to address it very quickly?
I believe so, Your Honor. Primarily what I'm looking for are the actual formal search warrants, primarily seizing the social media accounts of my client. And those are primarily what I'm waiting for. And I think that includes both the Gmail and the Facebook and there may be one other, which I'm not 100% sure. And so those are the primary ones I'm looking for, although Ms. King has, I think, represented to me that there was more material, I guess, actually not transferred to the portal than even I expected. And so I'm not certain what else they will be posting on the portal.
And so then going back to the motion for continuance, I believe it was a defense motion for continuance, or is it agreed? It was an agreed motion for continuance filed by the state. That's what it was.
Correct.
And that was filed back on September 26th. Again, we had our original hearing on October 4th. Well, it was scheduled. I need to know in terms of the it being an agreed continuance, I am going to honor your agreement on that because it's clear that we are not prepared to go to trial at this point. However, the primary concern that I have is, well, maybe twofold. Number one is getting an update from you all on outstanding discovery. And so what we'll do there is we're going to have a judges conference on November 29th at 3 p.m. That is Tuesday. It is our jail slot. That gives you all, I understand that the holiday is there's actually a couple of holidays in November, but I really need an update as to what is outstanding. And if what really is the case is that we're just a little bit late in the game and turning this stuff over, but it's all available and Mr. Anderson has time to review and you all can communicate if things are still outstanding. Then that'll be my turn to check in with you to make sure that that is happening. If you all are faster than the court, great, send your requests, file whatever motions need to be filed or amended or supplemented so we can get it scheduled for a hearing. I think I'm comfortable saying that any hearings on those types of substantive matters, I gotta think we're not gonna have it all wrapped up by November 29th. But at the very least, I want to use something of a target date, early 2023, meaning January, for any of those motions to suppress. But, you know, we'll just see where it takes us. I'll check in with you all on November 29th. Mr. Anderson, did you have an issue with that date?
With the 29th of November, no, Your Honor.
Okay.
And I mean, I'm fine if you want to pursue a motion to suppress hearing in advance of January. I mean, I'm going to assume that Ms. King and I will have been able to look at all of the formal search warrants which were filed by the officers or detectives before them. But
So Mr. Anderson, my thought is this, I'll give you all November to get everything squared away in terms of what's been turned over, disclosures, anything that might pop up in that evidence review. And then on the 29th, I am anticipating being able to schedule any motions to suppress, you know, as soon as we can schedule them. So we will reconvene on the 29th. For now, what I would also like to do is secure a trial date because this is clearly one, having gone past 2 trial settings already, that I need to specially set. And so I know it's hard to determine, let's say, you know, with motions like motions to suppress outstanding, what kind of turnaround time, but I need to get you a trial date and I need to make sure I have that specially set because so the calendar is already getting full for 2023 in special settings. So what kind of, knowing that there's still moving parts, what kind of turnaround time are you all looking at in terms of a trial setting?
Judge, I think I would be okay with trial as early as March of next year. If that works with your calendar. In February, I have January and February, I have several other cases set.
I'm looking at March 17th and March 24th. So let me go in and just look around. Myrna, if you will do the same on those dates. To see what we have, say, you know, the week before to make sure that we don't have anything that would encumber this particular trial date. Let me make sure I have the right month. Yep, March 17th, St. Patrick's.
Your Honor, if I may, we do have the capital murder, I believe, is scheduled for March 9th.
Which one is that? Let me go back in the
For
calendar.
Phillips Mills. It's especially set on the 9th.
Yeah, so that's not going to work. So let's go to the 24th. I feel like this is like February, March, April is already a busy calendar, but let me see. The 24th and the 23rd, because I think, well, Mr. Marufo, do we have Commissioners Court reservations yet for those dates?
We do have it for the 24th, Judge. We can ask for it on the 23rd. I don't see nobody assigned to it.
Okay, so the only thing, do you all have an idea of how long you think the case will take? I know that's a terrible question to ask. The reason I ask is because we come up on several holiday weeks, so it means that we operate on short weeks, with Cesar Chavez Day being on the 31st, and then Good Friday being on the 7th of April. Do you have any feel for time-wise how long the trial might take? At least evidence.
Judge, I think it can be tried, assuming we pick the jury on the Friday before.
Mhm.
I think we can accomplish it in the evidence in the following week.
Okay. So the following week it's a short week. Okay. So we're going to go with that date. We're going to go what is going to be actually the 23rd of March. That's a Thursday. I am going to attempt to reserve Commissioner's Court for that day so we don't have to do multiple panels. And then we'll have our additional panel in Commissioner's Court on the 24th.
Judge, there may be some, are you saying that we are not available the 31st?
31st is a county holiday and the 7th is a county holiday. And so what I will tell you with that is if we were to get our jury from that first panel on Thursday, we would start evidence on Friday.
I think if we start that Friday, I mean, I don't want to speak for Ms. King because she's the one who's going to put on most of the evidence. I think we can accomplish it by the following Thursday. There, as you know, there may be some mental health.
I don't have an issue, Mr. Anderson, if we go past the 31st. I'm just letting you know we won't have the 31st. If we're still in evidence, that will be a holiday, so we'll have to start up again on the 3rd.
Understood.
Okay. So
23rd is good for me, Your Honor.
okay. So then we're going to schedule it. I will also be backing that date up in the event something goes awry. Okay, but I want to schedule you now because trial settings are tough. Special settings are tough to accommodate. But we'll get that one with an additional backup date. We will reconvene on the 29th. If there are any issues, we can discuss them then. The motion for continuance is granted. We're in for 30 days and then we'll look at any other settings before then. If you all know, and Mr. Anderson, if you know before the 29th that you filed some other suppression or you're wanting to go on those that are already been filed, please email Ms. Hernandez with the request for hearing and we'll get it scheduled because maybe we can get it done before the end of the year.
Sounds good, Your Honor. Just so that there's no misunderstanding, Ms. King, I'm not available this Friday, so we can do it the following week if that's okay with you to look at the evidence itself.
Okay.
Okay. I'll leave that to you all to get together and have an update for the court on the 29th. Okay.
Thank you, Your Honor.
Is there anything else?
Not from the state.
Not from the defense, Your Honor.
Yeah, all are excused. Thank you for your time. Thank you, Mr. Alvarez. Who's next?
Mr. Anderson has another client. Alex, may we have Sergio Lopez?
Is Mr. Lopez still here? Our attorney Lopez? Because then let's get Mr. Carrillo because Mr. Lopez is just waiting in the.
Okay. Annex.
Carrillo. Get Carrillo, sí.
This will be very quick. Is he a Spanish speaker, Mr. Lopez? You're muted.
He's bilingual.
Go ahead.
In cause number 2021-0D01748, State of Texas versus Cristobal M. Carrillo. Announcement of council, please.
Samantha Rock on behalf of the state. State's ready, Your Honor.
Enrique Lopez on behalf of Mr. Carrillo. We're ready, Your Honor.
And Mr. Carrillo is appearing remotely from the jail annex we had anticipated, or we thought we would potentially be at a plea, but today is our final hearing plea deadline. Ms. Rago, what's the rec on this case?
The rec is 10 deferred, Your Honor, on all counts except for count 1, Your Honor.
Okay. And I don't know if this was the exact same rec from last time, Mr. Lopez, but in an attempt to expedite things, and so your client, Mr. Carrillo, understands, we have requested that he be transported physically here to the courtroom so that you can meet with him. And if we are at a plea, which I think I've heard is what's going to happen, that we can do that expeditiously here in the courtroom, okay?
Yes,
Mr. Carrillo, do you understand that?
Yes, ma'am.
Okay, so we're requesting to have you transported here tomorrow and you can meet with your attorney, okay?
Okay, and one question. Was
Mhm.
the same plea deal, right?
I didn't hear him. What's that?
Are we still going with the same plea deal?
So the offer that they made was 10 years deferred on all but 1 count. Your attorney will discuss that with you thoroughly tomorrow before we do anything. Okay, it is going to be a continuation of the final hearing plea deadline, which is scheduled right now. We're just trying to get you over here so that if it's a plea, that you will be able to talk to your attorney quickly, okay, rather than have to wait another week because it's probation and you're in custody.
Oh, Your Honor,
Understood.
I'm gonna go see him tonight.
I'm sorry?
I'm gonna go see him tonight.
Oh, okay. Well, there you go, Mr. Carrillo. Alrighty, we'll see you all tomorrow. Thank you, Mr. Lopez. Apologize for the delay.
No problem, Your Honor. Thank you very much for your time.
Thank you. Okay, now we can go to Mr. Anderson's other client.
And next, may we have Lopez, Sergio Lopez. Mr. Lopez, is that you?
Sorry?
Is that you, Mr. Lopez?
Yes, sir.
In cause number 2022-0D02849 and 2022-0D02620 and 2022-0D03358, State of Texas versus Sergio Abel Lopez. Announcement of council, please.
Samantha Roggenbath, on behalf of the state. State's ready, Your Honor.
Greg Anderson for Mr. Lopez, ready to proceed, Your Honor.
And Mr. Lopez is appearing from the jail annex remotely. Let me see, we're scheduled for pleas on all of these cases. However, I understand that cause number ending 3358 is due to be dismissed. Is that right?
Yes, Your Honor.
Okay, and just to be clear, I did review the plea paperwork. Did your office, when did your office contact, I think there's a victim in the 3358. What was the last contact you had with that complainant?
So we had, let me pull up the case, sorry. We attempted in September and then she was notified that the case was going to get dismissed, Your Honor. That was as of today.
I'm sorry, she was notified what and when?
So she was notified in the last 2 days about this case, Your Honor, that it was going to get dismissed.
Alrighty. Mr. Lopez, in these cases, as I mentioned, we're scheduled for pleas in all 3, but the pleas are actually going to be on the cause number ending 2849. That's the possession case, and then 2620, that is the robbery, okay? Is that your understanding of what we're doing here today?
Yes, Your Honor.
Okay, so in order to go forward, I need to swear you in. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, Your Honor.
Thank you very much. You can put your hand down. Would you please state your name and date of birth for the record?
My name is Sergio Abel Lopez. My date of birth is February 7, 2001.
Mr. Lopez, as I mentioned, we're scheduled for pleas, so there were documents you should have reviewed with your attorney. So when I refer to them, it's going to be one set for each case. They are marked as State's Exhibit number 1. Those are the plea papers for each of these cases. Within those documents, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Lopez, do you recall reviewing State's Exhibit number 1 for each of these cases with your attorney and signing those documents?
Yes, Your Honor.
Did you understand everything contained within those documents?
Yes, Your Honor.
Mr. Anderson, have you had more than 10 days to prepare defenses in these cases?
I have, Your Honor.
And did you explain the plea papers to your client?
I did, Your Honor.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his pleas today?
I do.
Mr. Lopez, are you satisfied with your attorney's representation of you?
Yes, I am, Your Honor.
Mr. Anderson, any reason to believe your client is not presently competent to enter his pleas?
None, Your Honor.
Mr. Lopez, have you ever been found mentally incompetent by any court?
No, ma'am. No, Your Honor.
Ever been examined by a doctor or psychiatrist who has found you mentally ill? I'm sorry?
No, no, Your Honor.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas. Sir, are you a U.S. citizen?
Yes, ma'am. Yes, Your Honor.
Where were you born?
El Paso, Texas.
Okay, in cause number ending 2849, the charge is possession of a controlled substance in penalty group 2 in an amount between 4 and 400 grams. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty, Your Honor.
In cause number ending 2620, the charge there is robbery. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty, Your Honor.
Are you making each of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Ms. Rago, would you summarize the evidence, please?
Yes, Your Honor. If the state of Texas were to proceed to trial in cause number 2849, the state would have proven beyond a reasonable doubt each and every element listed on the indictment. Specifically, on or about the 12th day of July, 2022 in El Paso County in the state of Texas, the defendant did then and there intentionally or knowingly possess a controlled substance, namely tetrahydrocannabinoid in the amount of 4 grams or more, but less than 400 grams. State of Texas versus Sergio Abel Lopez in cause number 2620. If the state of Texas were to proceed to trial, the state would have proven beyond a reasonable doubt that on or about the 11th day of July, 2022 in El Paso County in the state of Texas, the defendant did then and there, while in the course of committing theft of property with the intent to obtain or maintain control of said property, intentionally or knowingly threaten or place Manuel Sosa in fear of imminent bodily injury or death. The recommendation is 5 deferred, Your Honor. On cause number ending in 2849 and 2620, a $2,000 fine, probate 2,000, 300 hours of community service, no contact with Manuel Angel Sosa, screen for TAP, mental health screening, curfew, all other standard terms. In addition, these cases are to run concurrent in the cause number ending in 2849 and 2620, pleaded 2022 0C03116. In addition, forfeit the weapon and dismiss 2020 0D03358. At this time, the state moves to enter into evidence Exhibit 1 and 2.
Any objection?
Objection, Your Honor.
States 1 and 2 are admitted. Is that your understanding of the plea agreement, Mr. Anderson?
It is, Your Honor.
Mr. Lopez, is that your understanding as well?
Yes, Your Honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights because these are plea bargained or negotiated cases. You do not have an automatic right of appeal. Mr. Lopez, do you recall reviewing the trial court certification with your attorney and signing those documents?
Yes, Your Honor.
Finally, we have the motion for deferred adjudication. Mr. Lopez, do you recall reviewing the motion for deferred adjudication with your attorney and signing that document?
Yes, Your Honor.
Mr. Anderson, have you explained to your client both the benefits and detriments of deferred adjudication?
I have, Your Honor.
Mr. Lopez, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for these offenses? The full range of punishment is for anywhere from 2 to 20 years. Do you understand that?
Yes, I do, Your Honor.
And are you asking the court to grant you deferred adjudication?
Yes, I am, Your Honor.
I will find in each of these cases that there is sufficient evidence to substantiate findings of guilt. However, I will not enter findings of guilt at this time. Instead, I will defer further proceedings and place you on community supervision pursuant to the plea agreement for a period of 5 years. There will be a $2,000 fine. The entirety of the fine will be probated, which means that you will not owe the fine unless you are non-compliant with your probation terms. 300 hours of community service, screen for TAP and mental health services, urine and breath analysis, curfew. I am going to include on here, I'm not sure that it was included on the plea paperwork, that you are to possess no firearms or ammunition whatsoever. You're to have no contact with the complaining witness in this case, and you're to have no offensive contact with the complainant in cause number 2022-0D03358. I believe that is Maria Estrada. You will also attend parenting classes, and you're going to be subject, aside from your regular testing, you're going to be subject to 2 random tests a month with 24 hours notice. And so with that, there is also a dismissal forthcoming in cause number 2022-0D03358. I think that's it. The other case is a misdemeanor case. Is there anything further, Mr. Anderson or Ms. Rago?
Your Honor, I just submitted the dismissal.
Okay, so I'll sign off on the dismissal as soon as I can get to it.
Your Honor, if I may just briefly address my client on some of those issues. Mr. Lopez, you're still allowed to have contact with the mother of your child. I think that's what the judge was addressing, but it cannot be any offensive contact. I think based on what you've experienced, it's probably wise for you to have somebody assist in custody exchange, okay? If you are going to pursue that. So that is one of the conditions on your probation, okay? You understand that, sir?
Yes, sir.
Okay.
Thank you,
Secondly, your misdemeanor case, I'm sorry I was not able to accomplish the plea on the case this week. You'll be doing it next Monday, okay? You can post bond on that, although you'll be pleading to one case, and as I understand, the other case either no longer exists or will be declined, okay?
Yes, sir.
Was that everything, Mr. Anderson?
It is, Your Honor. Thank you very much for your patience.
No worries. Thank you for clarifying. Thank you, Mr. Lopez. Who's next?
Thank
And
you.
next, we have Lozoya, middle of page 7, bottom of page 7, Judge.
Judge, I hate to jump in, but I wonder if we could take care of mine real quick.
Oh,
Ms.
right.
Boteo,
That's
since she's
Mr.
not present.
Yeah, Mr. Munson, are you on that one? And then we'll take care of Mr. Lozoya.
Yes, Your Honor.
So I did get the update. If I'm not mistaken, Myrna, did we refer this one already?
Yes, Judge, it's been done.
Okay, so I think we did receive an update, Mr. Morales, from Mr. Munson. At this point, it's been, I think, very difficult to schedule you all and keeping you all on the trial track. So I did refer you all to Judge Alcala's docket. What they generally do is set you for a status hearing. Basically, I think so the judge can get a handle of what's at issue. I'm assuming he's going to ask what the status is from Mr. Munson, because that's the only thing outstanding. I just, it's very difficult to keep a case like that on my trial docket when we have so many others that actually need to go to trial. My understanding was this was going to be a plea, wasn't it, Mr. Morales?
Yeah, I thought so too, Judge. And then there was all that mess that happened in New Mexico, and now it's just we're just stuck in the mud, as it were.
So that's what I did. Like I said, I don't know how quickly with the holidays they're scheduling you all, but you should be receiving a setting from Lisette and Judge Alcala fairly soon.
Okay. All right, Judge.
Thank you for your time.
Thank you, Judge.
Okay, so now we need Mr. Olivas' guy.
Thanks, Judge.
You're welcome. Take care.
Hi, Judge.
Hi, can we call it, please?
In cause number 2021-0D01623, State of Texas versus Joshua Willie Lozoya. Announcement of council, please.
Samantha Ragg on behalf of the state. State's ready, Your Honor.
Jesus Olias on behalf of Mr. Lozoya, we're ready as well.
Mr. Lozoya is appearing remotely from the jail annex. We're scheduled for a bond hearing today. Mr. Olivas, you may proceed.
Yes, ma'am. Judge, I was compelled to file a bond on this motion that I believe his probation was revoked because he picked up a misdemeanor criminal mischief. With that being the case, Judge, he's a young man, as you can tell by looking at him. lifelong resident of El Paso. Unfortunately, he has had quite a few run-ins off and on, a lot of misdemeanor stuff. However, I need to resolve this issue at your level and then approach the misdemeanor court.
So it's a motion to set bond. He's set for trial in April. I mean, what are we, is there a probation case?
There's actually been an offer probation with restitution up front. And that was right before he picked up this case. Being a criminal mischief, I don't know that it's really going to change the rec.
Okay. So his bond is 50,000, right?
Yes, ma'am.
Okay.
And honestly, Judge, you can't afford anything at this point.
Okay. All right. Is that everything?
Yes, ma'am.
1623. All right, Ms. Ruggles?
Your Honor, the state's concern on the criminal mischief, the NISI was submitted because he didn't show up to court. That was on 6/16/2022. And that's the state's concern is failure to appear. He does have multiple arrests. For his criminal history, there was possession of a controlled substance, PG2, 4 to 400 grams, that was ultimately dismissed in 2020. Possession of controlled substance, PG3, 3 to 28, that was dismissed as well. A POM in 2020, less than 2 grams, that was dismissed. An AFE, impeding breath, that was also dismissed. There was some juvenile. It looks like there was a possession of a controlled substance, PG1, less than 1 gram, and he received probation, Your Honor. And so main concern is him not showing up on the misdemeanor. And just to clarify as well, Mr. Olivas, the restitution's $1,000, but it doesn't need to be upfront. It can be paid out through probation.
Okay, well, thanks for clearing that up because that was going to be an issue. And I don't know what's going to become of this criminal mischief. I don't know if it's going to be any restitution on this particular misdemeanor case. And I know he's been sitting in jail for quite some time, about a month, if I'm correct, but.
Marissa, can you clarify for me? I had him down as being held on the ag assault public servant. Let me make sure I'm not. On the ag assault public servant, is that right?
That's what it should be.
He's not booked on that. I think he posted. Because the only thing that's showing as active is the criminal mischief.
Right. I mean, this is what's throwing me off. I had written in my notes, and I'm actually not sure where I got this, that he was at 50,000, but the booking, the surety bond he posted back in April, and that was 2,000. Where am I getting the 50,000 from?
I don't know. 21.
Ag assault.
It's not on a rebel of the bond.
So back in May of 2021 is when he was booked on the, it says aggregated assault against a public servant. And he was out in 16 days. Yeah, he's not booked on the ag assault.
That was strange.
Am I right on that, Marissa?
That's correct, Judge. And it looks like it was just surety, so they would have had to surrender or get it forfeited, but nobody did. So he's just on the mischief.
Yeah, he's just on the criminal mischief. He's not being held on this case. So.
Well, watch him bond out, and guess what? He'll be right back in. That's a possibility.
It's possible.
It's possible.
But
okay.
He's not being held on my case. So.
That being the case, Judge, I'm sorry for taking up your time. Let me go talk to the county court and see what we can do at that level.
All right. Thank you very much.
Right. Thank you.
Take care. Who's next?
Judge, we have Ms. Valdez here for Mr. Yanis. Page 8, Judge, on.
Let's get off of YouTube.